Good morning again. Good morning, everyone. Thank you for being here. Thank you for your interest in our webinar on the subject of the legal aspects of secondary use of health data in the European health data space. We will focus on its impact on biobanking and implementation in Austria. So the decision on the topic was a collaborative one between our work package 2 here at the University of Vienna and our consortium. So we do hope that we have catered to your interests in our approach to this topic and that you find this presentation useful. I believe you're acquainted and familiar with our team here from UniV. Presenting today are my colleagues Claudia and Katarzyna, who will take the floor with me to share today's quite comprehensive agenda. So if we look at our agenda for today, Claudia will start by providing you with a brief introduction and overview of the European health data space, and will cover the provisions regarding secondary use of health data, and emphasizing on the progression from the General Data Protection Regulation to the European health data space. Section 3, which I will cover, will focus on the general implications of this regulation for biobanks. And then my colleague Katarzyna will take over and finalize by taking a look at the regulation's potential implementation in Austria. We have reserved some time after this for a discussion with participants, so we will have time for some questions from our audience today, and this component of the event will not be recorded. After a brief break, you're also welcome to join us for a workshop on the topic, and we hope to see you there as well. Without further ado, let me then give the floor to Claudia to start with, and I hope you find today's meeting fruitful. Thank you.
Thanks a lot, Katarzyna. Good morning, everyone. I will start right off and we'll tell you a little bit more about the European health data space. First, some very general information, and then a little bit more about the secondary use system and the EHDS's relationship to the GDPR. So the European health data space is an EU regulation, which was very recently finalized by the European institutions, and it is part of European data strategy, which aims to create a single market for data in the EU. And the European health data space is focusing on the health data aspect of this strategy. We do not have yet a final published text. We are still waiting for that, but we already know what the final text of the European health data space will look like. And with that, the regulation has three main goals. The first one is to facilitate the exchange of data for the delivery of healthcare across the EU and to give individuals control over their electronic health records. This is the so-called primary use of data. Secondly, the EHDS wants to provide a system for the reuse of health data for research, innovation, policymaking, and regulatory activities. That's the secondary use of data. And finally, the aim is also to foster a single market for the European health records, electronic health record systems, sorry. Since we are focusing on the secondary use of data today, that's the definition of the EHDS, which defines secondary use of data as the processing of electronic health data for purposes other than the initial purposes for which they were collected or produced. And moving on with some other basic definitions in order to build on to what my colleagues will discuss about, the European health data space uses the definition of health data or data concerning health from the GDPR. That's why I'm providing this definition here. And just as a reminder, data concerning health in the GDPR means personal data related to the physical or mental health of a natural person, including the provision of healthcare services which reveal information about his or her health status. And this is also where we sort of see the first interoperability element between the European Health Data Space and the GDPR. However, the European Health Data Space has a little bit of a broader definition of what are health data, what are electronic health data. So on one hand, we have personal electronic health data. That is where we adopt the definitions from the GDPR. That is where also the GDPR and the European Health Data Space coexist. But the European Health Data Space also regulates the sharing of non-personal electronic data, and these are defined as electronic health data other than personal data. This includes data that have been anonymized and are no longer relating to an identified or identifiable natural person, or data that never related to a data subject in the first place. And wherever in the text the EHDS refers to electronic health data, both personal and non-personal electronic health data are meant. This distinction between personal and non-personal is of course important because there are stricter measures for sharing and processing personal health data, and these are largely covered by the GDPR unless the EHDS specifically explicitly refers from it. There are several main actors under the European Health Data Space secondary use system. Katarzyna and Katarina will talk a bit more about the specific definitions, but these actors are health data holders, health data users, health data access bodies, and natural persons or data subjects. And moving on to the interoperability and some of the overlaps and maybe some of the conflicting provisions between the GDPR and the European Health Data Space. In the next two slides, I've highlighted some of the important elements here, since they're also important to biobanking and the data used in biobanks. So as already mentioned, when it comes to personal health data, the GDPR and the European Health Data Space coexist and they both apply. And so, for example, a health data holder under the EHDS is deemed to be the data controller under the GDPR, meaning they still have to comply with all the obligations and requirements of the GDPR, such as compliance with the general data processing principles. Furthermore, the European Health Data Space gives a bit of a clarification in recital 37 on the legal basis for processing data under the GDPR. So it mentions that the EHDS provides this legal basis under both Article 6 and 9 to also process sensitive data within the secondary use system of the European Health Data Space. What it does not, for example, specifically mention is broad consent. So it could be a possible discussion point as to in how far broad consent still counts as a legal basis for processing data under the European Health Data Space. Another important point is Article 14.5 GDPR, which is about the right to information of data subjects. The GDPR limits this right to information in case of secondary further processing of personal data, among others for research purposes. And this is possibly a limitation that continues to apply in the European Health Data Space secondary use of data. Additionally, when assessing a data access application, health data access bodies will need to check for compliance with the GDPR. We can see this in Articles 44 to 47 of the EHDS. And national supervisory authorities under the GDPR also have a role under the EHDS. And so, for example, they are responsible for monitoring the enforcement of the right to object to the processing of personal electronic health data for secondary use. So this is the so-called opt-out mechanism. And moving on to a bit less explicit but still important relationship between EHDS and GDPR. Under Article 34, the purposes are listed for which electronic health data can be processed for secondary use. And I think important in this case is that data can be used for scientific research related to health and the care sector. And in this case, the EHDS also interprets scientific research in a broad manner, as including, for example, technological development and research, both privately and publicly funded. This is very similar to the notion of scientific research that the GDPR adopts, which is also quite broad. Furthermore, the EHDS prescribes that electronic data are always to be shared in anonymized form, unless it is necessary for the specific secondary use purpose that they be shared in pseudonymized form. And the definitions of anonymization and pseudonymization are also taken directly from the GDPR. And finally, health data access bodies can only provide access to electronic health data through a secure processing environment. This is also there in order to ensure the protection of data protection rights, to ensure appropriate technical and organizational measures to prevent the unlawful processing of personal data. And this brings me to my final point, which is slowly moving to the role of biobanks and to biobanks in the European health data space. We have two explicit references to biobanks, one in recital 64, which mentions biobanks as one of the instances of data that can be affected by the risk of re-identification of personal data. And the second mention, very important one, is in Article 33, where biobanks are mentioned as one of the data categories that can be used for secondary use under the EHDS. And I will stop my screen sharing now and give the floor to Katarina.
So good morning again. I will pick up in this section from Claudia and cover some of the interesting consequences that the European health data space will potentially have for biobanks. So as far as scope of application goes, an important point to emphasize for biobanks is that the regulation is due, like Claudia said, to cover primary and secondary use of personal electronic health data. And this is due to include data retrieved from an analysis of biological samples from natural persons, which is very much in line with the work carried out in biobanks and the data which is stored in biobanks. This excludes from its scope of application all biological samples. So the requests to access and transfer those should be managed at a biobank level in accordance with the regulations that are applicable, both at national and European levels. And as you know, the legal framework applicable to international data transfers is very much a byproduct of the European lawmaking, and the GDPR mainly is a big contributor to this framework, and the European health data space is due to add to it. If you can look at Article 61 and 63, for example, for that. As far as the role of biobanks within the European health data space, as has been explained, there are many actors involved in the data processing described in the European health data space regulation. One of those entities, like Claudia mentioned, are data holders, and biobanks can potentially be qualified as entities performing research in relation to the healthcare or care sectors, which is one of the activities which Article 2 describes as being carried out by data holders. Nevertheless, as we know, there is no uniform concept of biobanks and activities carried out by biobanks at the European level. So whether biobanks will be classified as health data holders for the purposes of the regulation will also largely depend on the member state's national law regarding what type of activities a biobank can carry out. If they're indeed classified as a health data holder, this comes with certain obligations. The epicenter of those obligations is making data available for secondary use within the categories of data that have to be made available for secondary use. The health data from biobanks and associated databases is specifically mentioned. Regarding the way in which this will be made available, this will largely depend again on each member state. This is because as the data stored in biobanks can be considered of increased sensitivity and value, member states will be able to introduce stricter measures and additional safeguards at national level. And for that reason, the implementation of the European Health Data Space Regulation regarding access to biobank data will not be uniform. And this is only the first example which we will have as such potential fragmentary application of the regulation. In terms of the content of the mentioned Article 33, we have observed that it has generated some interest among the scientific and legal communities. And we can take a look at two of the comments that have been raised. First of all, it is not clear whether the requirement to make this data from biobanks available refers solely to polyuser biobanks or those collections of samples which are stored, for example, by research companies or universities. This is a complex issue because, as mentioned previously, we don't have a European-wide definition of biobanks. And we also do not have a uniform classification system regarding biobankings either. The regulation does not provide us with a definition in Article 2 of the concept of biobanks. Therefore, interpreting the provision is a little bit more of a complex task. Nevertheless, whether a specific biorepository is a biobank will be resolved by national law. Regarding the case of individual researchers, we know that in some jurisdictions they're allowed to keep their own sample collections. Nevertheless, the European Health Data Space does not necessarily qualify them as data holders because there is an exemption in place for individual researchers, so they are not required to make electronic health data available for secondary use. And nevertheless, again, member states may not implement this exemption, and there is, of course, here then potential for a very different approach in how the European Health Data Space Regulation is applicable. Looking into another comment that has been made is pertaining to whether the research purposes of biobanks fit well within the concept of secondary use. Regarding this topic, there can be interest in secondary use of the data collected and stored in biobanks. This is because the primary scientific purposes of the collection of data is not really incompatible with pursuing a secondary processing of this data. There is, as Claudia mentioned, no unlimited spectrum of purposes which fit the concept of secondary use. Actually, Article 34, as we have seen, presents a very select range of purposes, including, of course, then scientific research related to the health or care sectors. And this can be a natural progression of the primary use of the data which is collected and stored in biobanks. Also, it's important to emphasize that biobanks can qualify potentially as health data users and also benefit from the legal provisions regarding secondary use. Moving on to their role as contact points, as we mentioned, another category of actors emerging from the European health data space are the health data access bodies. Within the tasks of this body is making available data for secondary use. Biobanks have had a long-standing role as interfaces between researchers, as we know, and data and the samples which are stored in biobanks. So for many people, this may be viewed as becoming compromised with the emergence of the health data access bodies, but we have to see it at the same time providing an opportunity to enhance biobanks' profile as key actors in research and data management and not simply as sample storage facilities. Covering the topic of ethics, as the wording of the regulation currently stands, we really don't have measures put in place to protect from unethical secondary use. As we manage, there is emphasis placed on data protection, also with the interoperability with the GDPR. We also have structural principles such as data minimization, purpose limitation, and anonymization of data. And therefore, the measures that are currently in place within each member state requiring ethics committee approvals prior to data sharing for secondary use, there are no measures implemented at the regulation level, which will, of course, result in a non-harmonized ethical approval process within the EU. For this reason, there were calls to involve ethics committees within the framework of the regulation, but it's now left out to the member states to implement this at their discretion. They might include, again, an ethical assessment as part of secondary data sharing, or they might even include their ethics bodies within the configuration of their health data access bodies. But again, the configuration will now depend on individual member states. As far as returns of results decisions go, there are various issues regarding the collection of consent from natural persons whose data can be shared for secondary use purposes. We have the issue of withdrawal of consent, which is now included in the opt-out system Claudia mentioned. We also have the broadness of consent. For example, if a biobank is obliged to share data for secondary purposes, which go beyond what the data subject, so the sample donor, initially provided consent for. And we also have the incidental findings issue, so rather the issue to be informed of these significant findings that health data users might identify in the research they pursue. For example, whilst on the Commission proposal, the decision on whether to return the results was resting with the health data access bodies alone, we do believe that the current wording does recenter to a certain extent the management of such proceedings back to the biobanks as health data holders, and this will be governed by national law. So whichever provisions we have in place in Austria, for example, relating to genomic findings, which are governed by the Gene Technology Act, all of these are still potentially due to be in place. Speaking of Austrian law, I will now give the floor to Katarzyna, who will cover the implementation of the regulation in Austria.
So today I will focus on selected topics that are of relevance at the Austrian level when it comes to the implementation of the European Health Data Space and the solutions provided in its provisions. I would like to start with mentioning current issues that exist with regard to secondary health data use in Austria, and hopefully some of them can be addressed by the European Health Data Space, since the regulation itself will require a more unified approach across Europe. So first of all, what has been raised in several research studies that pertain to European Health Data Space and also the status of Austria when it comes to secondary use of data is the quality of the data that are collected for primary use that then impact secondary use. Here, the European Health Data Space provides the solutions that should enable the primary use case data collection of the data for primary use case to become more unified, and then thanks to that to achieve the situation in which the data sets that were collected for primary use would then be better interoperable with regard to the secondary use opportunities. Another issue that has been raised is the possibility to link the data among the data sets. And here that refers to also the third point, which means in Austria we face the decentralization of the databases containing health data, and we face data silos. So we do not have one structured data type, and we also face the situations where in the context of the primary use and the collection of information, there are instances where the entities use free text data and capture them in this manner in health records, and that again can also impact the secondary use. Another point is to, with regard to the appointment of the entities that would be responsible for data sharing for secondary use in line with the EHDS. And here, as Claudia mentioned in the first part of the presentation, we have different actors that are defined in EHDS, Among them, we have health data providers, and also we have health data access bodies that should be appointed by the member states. And in the context of Austria, the issue that emerges is that we do have several agencies and authorities that could take up this role. Tackle this topic in the context of BBMRI and Austria, but also BBMRI ERIC, how this could potentially be solved in the context of the biobanking. With regard to the initiatives that at the moment tend to support the EHDS implementation, there are a few examples that we can name at the moment. So first of all, the Austrian Microdata Center that is run at the Austrian National Statistics Office is named as one of the solutions, one of the infrastructures that could support EHD implementation and the access to the data, remote access to the data for the secondary use. This Austrian Microdata Center is being developed at the moment. However, what also has been raised by different stakeholders is that at the moment, the datasets available in AMDC are not that broad yet, so there is room for improvement here. Additionally, in the context of the regulations themselves at the national level and legislation procedures, there is the aim to implement solutions for joint data management in federal target management. And here, just one example to show from January, 1st of January 2024, we have the Bundesgesetz zur partnerschaftlichen Zielsteuerung Gesundheit GZG with its paragraph 11 that states that the state, but also regional health institutions and social security entities should jointly establish a platform for health data. So that would be a joint platform that would allow for collecting the primary use data for the purposes of secondary use, and that should also be compliant with the data protection requirements provided at the European level in the GDPR, as well as in the Datenschutzgesetz in Austria. Nevertheless, the platform itself is under the development, and it should be technically ready by 2028. So there is still a bit of time, and we will still be waiting for a bit to see the final results of creating such a platform. And another point that should support the EHDS implementation is the improvement of ELGA system. ELGA system has been named as the system that is already prepared in a quite good manner for the collection and access to the data, health data for primary use. Nevertheless, it would still require some improvements to support the secondary use of data. And with regard to further points that are of relevance for biobanks and the implementation of EHDS at the national level. So first of all, as I mentioned before, there is a requirement that every member state should appoint or nominate one or more health data access bodies. Here, when it comes to the Austrian ground, there have been discussions on who could assume such a role. The possible entities that were mentioned are, first of all, Statistik Austria, but also ELGA, Sozialversicherung entities. But there is also the room to provide another existing actor or a new specially established legal entity that would become health data access body. And here there is a point which perhaps could support biobanks in the secondary use data exchange, namely the scenario that has been suggested by BBMRI ERIC is to appoint BBMRI-ERIC as one of the health data access bodies in the member states and also observer countries, because then BBMRI-ERIC would step in the role of the entity that would receive access applications, that would collect data from data holders who, as Katarina mentioned, potentially could be biobanks. And BBMRI-ERIC would be in charge of providing the data for the secondary use to the data users. Additionally, what is of relevance here is that the member states should implement an opt-out mechanism for secondary use of data in an even manner as in other member states. Hence, when it comes to the biobanking environment, that would be also of relevance, BBMRI-ERIC, but also BBMRI Austria, to follow the guidelines in this regard and to support the provision of the opt-out mechanism in a unified manner, similar to the manner in other member states, so that the cross-border data exchange for secondary use would be enabled. And additional point that would be of relevance from the biobanking perspective is the implementation of the opening clause from the EHDS in Austria that pertains to agreeing on the scope of categories of data where opt-out would be excluded due to disproportionate effort or due to the fact that it may render research impossible or seriously impair the objectives of the research. And here the decision has been left in the European health data space to the member states on how to approach this topic and whether to provide such exclusions in the national law. For the national health data access bodies, so potentially what could be of relevance for BBMRI-ERIC if the scenario that BBMRI-ERIC becomes a health data access body would be realized. So the requirements here you see just a snapshot of those. All of them are included in the EHDS Article 37 to 39. And to the main requirements that are of relevance belong the independence and freedom from instructions of the access point for its area of activity. So here BBMRI-ERIC would need to be characterized with this independence and freedom. Further, the human resources, finances, and expertise to support the national health data access body tasks and exercise of its powers should be in place. And we assume that BBMRI-ERIC has such resources available. Another requirement posed for national health data access bodies is the democratic control of the access point for health data in accordance with the European health data space. Also close cooperation of the access point with the data holders, especially with regard to providing and maintaining the data quality, as well as the cooperation with the data users. And here BBMRI-ERIC would fulfill this task, since already BBMRI-ERIC cooperates closely with data holders that are different entities that maintain biobanks. The additional requirement that is also of relevance is for the national health data access body to provide measures necessary to preserve the confidentiality of IP rights and regulatory data protection, as well as the confidentiality of trade secrets. We should not forget that those are the aspects that should be considered in the context of sharing the data for secondary use. Perhaps I will focus on the last point, which is also very relevant, is that health data access body is the body that would receive, combine, prepare, and compile necessary requested data from health data holders, and will be also in charge of pseudonymizing them or anonymizing them. So here also BBMRI.at, if again the scenario would happen that BBMRI.at becomes health data access body in Austria, this entity would be in charge of fulfilling such requirements. And here I collected several articles from the European Health Data Space regulation, which are considered opening clauses, which means member states, and among them Austria, would be in charge of implementing, transposing them, and providing additional solutions at the national level in the legislation. And here, one of them is Article 32, which provides that individual researchers or micro enterprises could be excluded or included in a group of subjects to the provisions that pertain to secondary use of health data, electronic health data. Additionally, member states, Austria, can establish higher standards concerning technical and organizational means safeguarding the data stemming from the biobanks, so electronic health data. Also, Austria needs to indicate health data access bodies and report them to the Commission. Member state will also have the open room to provide opt-out solution for natural persons with regard to enabling a secondary use of data, and also the member states are in charge of providing exceptions in this regard. Additionally, there is also a type of entity that is defined in the European Health Data Space, which is called Trusted Health Data Holder. And here that will be also at the discretion of the member states to establish a procedure according to which an entity could obtain such a title. And that title is related to the, let's say, easier procedures to for the data sharing regarding secondary health data use. And furthermore, Austria needs to establish national contact point for secondary use of electronic health data that would be connecting to the big health data at EU repository. Further, with regard to the transfer of the data for secondary use internationally, and international access to such electronic health data. Here, Austria will also be able to provide limitations that, first of all, will take into account the GDPR requirements, but second of all, can add the limitations on top of what we see in the GDPR. Additionally, the requirement for the member states in cooperation with the Commission is to establish an easy-to-use platform for submitting complaints by the entities that are addressed by the European Health Data Space, as well as there is a room for Austria to establish the system of penalties for infringements of the European Health Data Space Regulation. However, to be stressed here is that there are some penalties already established in the European Health Data Space, and those should be respected and implemented at the national level as they are defined in the European Health Data Space Regulation. Nevertheless, not all of the types of penalties are defined, and those other types can be established at the national level. And another point that can be of relevance for BBMRI Austria and for BBMRI-at is the aspect of participation in the process of shaping the implementation of the European Health Data Space. Namely, there are two articles in European Health Data Space Regulation that provide that the Commission should consult stakeholders with regard to the manner of implementing the provisions from the regulation. And here they should establish a stakeholder forum that should be established in a procedure of a public call for interest. And this stakeholders forum should be composed of relevant stakeholders that would include, as mentioned here, representatives of patients, organizations, health professionals, but also scientific research and academia entities. And perhaps that's one point where once the public call is announced, BBMRI.at could apply, and also the partners from BBMRI Austria could consider applying for becoming one of the stakeholders that would be included in the forum. And those stakeholders should then support the European Health Data Space Board. That is a new body that is will be once we have the European Health Data Space published. This board will be established according to the European Health Data Space provisions. And here the stakeholders would support issuing guidelines on secondary health data use. And that can be, again, of relevance for biobanks to participate in such initiatives, to steer and to support the discussion on the guidelines and to make sure that the needs of the biobanks in this context are taken into account. And what cannot be forgotten is the fact that apart from European Health Data Space, we already have at the national level the regulations that refer to health data protection, and also the extraction of data from electronic clinical records. And those regulations need to be still addressed simultaneously to the European Health Data Space regulation. And they also provide the legal basis for processing the data for the scientific research purposes, for secondary use purposes. And here I just named two: documentation law that provides the legal basis for the documentation of health-related data in outpatient and inpatient care sectors, and also research organization law, Forschungsorganisationsgesetz, that provides legal basis for processing personal data for, among those purposes, also scientific purposes or statistical purposes. And here, according to the legislation, the data, before sharing them and conducting secondary use, they should be de-identified prior to analysis. So pseudonyms should be created. And also what has to be remembered is that the access to health data will require a legal basis, and those legal bases are included in, for example, research organization law for scientific research. And if such a basis is provided, then standardized processes will allow access to the data to research institutes and universities. Further, what has to be remembered is that at an Austrian level, there are various access mechanisms and monitoring processes that depend on each organization's own governance processes, and that should be also taken into account when accessing the data for secondary use. That apart from the EHDS, we still have different solutions at the national level. Hopefully they will be more unified once the EHDS enters into force, and that will also support the cross-border exchange of the data and support achieving the goal that the European Commission has, which means unifying the standards cross-border. That's it from my side, and I think that now we have several minutes for the questions that you may have.
Yeah, we'll also stop the recording at this point, so feel free to ask any questions you